right, ma'am, why was this eviction filed?
He didn't pay the May rent, not pay the rent. Yeah.
Okay, how much is the monthly rent?
2,300.
Is there any subsidy to you by the government?
So what's that mean?
Does the government pay her for any portion of his rent?
No.
So he owes all 2,300.
Yeah.
Okay.
May, and I don't know if we counted June. See?
Under your lease, what day is the rent due?
Huh?
Under your
A
lease,
third,
what day is
third.
rent due?
Yeah, every month third.
Yeah, okay. All right, Ms. Chang, is your property, does it fall under the Federal CARES Act?
What's that mean? Yeah. Oh, what's that mean? Can you explain?
As the landlord, if your mortgage is one that is specifically covered under a federal statute, you have to give them 30 days notice if it applies or not.
You mean the move off for 30 days?
Yeah, Ms. Chang, during the pandemic, the federal government passed a whole series of acts, and they were known as the Federal CARES Act, and it's an acronym that stands for things. But one of the provisions is that if you have a mortgage that falls within certain restrictions, you have to give your tenant a specific kind of notice before you can move forward with an eviction. And so I always have to ask the landlord, to your knowledge, if you're moving forward with an eviction today, if you are a CARES Act property and you evict him and you're wrong, you may be subject to federal penalties, including a lawsuit from him. So it's important to you that you know whether or not you're covered by this act.
You understand that?
It's about the.
1 second.
Is there a mortgage on the property?
No.
If there's
Then
no
it
mortgage
cannot
on the
apply. If you own your property free and clear, it cannot apply to you. Okay, cool. We're good.
Okay. Yeah,
So
no
no,
mortgage.
Federal CARES Act would not kick in because you don't have a mortgage on it. All right. Ms. Chang, was May the first time Mr. Funk had been late on the rent?
Oh, no.
Okay. When did you
Okay,
give him a notice to
let me read
vacate?
it for you. 2025, May 8th.
No, that's fine. Ms. Chang,
This isn't just a simple unpaid rent case. Before the judge can even discuss the eviction, he has to determine whether federal law applies. If the property falls under the CARES Act, the landlord could be required to give a different notice before filing for eviction. It's a reminder that even straightforward landlord-tenant disputes can involve important legal protections.
I don't need that.
Yeah.
I only have to know if he'd ever been late before. It matters about what type of notice you give. If you've been late before, you're solid. Okay. When did you tell him to vacate? When did you give him a written notice to vacate? What day was that?
May 12th.
May 12th. And how did you give it to him? Did you mail it, email it, stick it in the unit?
Mail, and I text it. Send a picture. Yeah.
You mailed it or emailed it?
I send the certificate mail.
Okay, you mailed it.
Also, I text him. Yeah.
Oh, okay. And you also text him. All right. Good afternoon, Mr. Fong. Thank you for being here.
Howdy.
All right. Now, my first question is, and I think I can read my handwriting, is the monthly rent $2,300?
Yes.
Okay. And is it correct that May and I guess now June as of yesterday remain unpaid?
Yes, I want to be very clear that I am not claiming that I owe nothing and I am not refusing to pay.
Okay.
According to the filing, the amount being claimed is $2,300 in rent plus late fees. I
Okay.
am prepared to cure the $2,300 immediately.
Okay.
I was not able to complete the deposit before this Zoom hearing today
Okay.
because the landlord, even though it states on the lease that she accepts electronic payments, she requires payment by in-person deposit at her bank. So the process requires me to go inside my bank, obtain a cashier's check, and then physically drive to her bank, enter the lobby, and deposit it. So I need to be present today at 2 p.m. So I did not have time to do that payment today. If the banks are still open and I have time, a lot of times the lobby closes at 4. And again, I have to go to my bank. I will do that today, if not first thing in the morning.
Tell you what then, I can give you guys an outcome and I'll give y'all some information and maybe this will get you all where you want to go.
Yeah, can I finish real quick?
Go ahead, Mr. Funk.
And I wanted to say, I also understand it's June 4th and rent is due. I am self-employed and I am paid through client invoices. So cash flow depends on when clients pay. I currently have 5,000 in outstanding invoices, which were supposed to be paid on Monday or Tuesday, but they have not paid yet. I cannot force clients to pay on a specific day, but I intend to pay June, hopefully tomorrow or Saturday. And as to the late fees, I have repeatedly requested a clear and itemized tenant ledger showing rent charges, payment received, and any late fees with dates and calculations so that I may match it to my records and resolve any verified balance. I have not been provided an itemized ledger, only handwritten notes that are not legible. So I cannot confirm what late fees are being claimed or how they are being calculated. And I have also repeatedly requested clear written accounting to the total security deposit and pet deposits the landlord is currently holding, so my records match the landlord's records. The lease reflects $4,600 in security deposits because out of goodwill, being self-employed, I offered to pay 2 months rent. But I also additionally paid pet deposits later. And when I asked to know exactly how much total deposit is being held, I was referred back only to the lease amount. And that is why I have been requesting both a readable ledger and a clear deposit accounting. I submitted all of my documents to the court, text, payment proofs I have, because I have been trying to resolve this directly and in writing without the court's involvement. My attempts to resolve this have not been successful. Instead, I have been told to get a lawyer and that we'll see each other in court, rather than being provided the basic accounting needed to reconcile this account. Today, I'm asking the court deny possession, as I do have the 2,300 ready to deposit, allow me to cure that rent immediately, and require that any claimed late fees, since they are dating back to over a year ago, be supported with an itemized ledger so that it can be verified and resolved. I've been doing my best to handle this responsibly and resolve it without the court, and I apologize for wasting the court's time today. And I hope that the court can see from my messages and documentation that I have been beyond proactive well before today's hearing by requesting clear accounting and proposing a path to get current. And I just also wanted to say I appreciate your time, and my goal is to cure this and get any verified rent balance properly verified with the proper documentation and resolve this without an eviction.
All right. Mr. Funk, I appreciate that. Unfortunately, the court is going to find in favor of the plaintiff because it is only necessary that they prove you didn't pay in full on time.
Here's the key legal issue in this hearing. The tenant isn't denying that the rent was late. In fact, he's offering to pay it immediately. But in an eviction case, the judge's job is limited. Once unpaid rent is proven, the court generally isn't deciding whether the landlord was cooperative or whether the tenant intended to pay later. The question is simply whether the lease was violated.
And that is not in dispute. April remains May remains unpaid. Even if I ignore June entirely, May has not been paid. An important part of what you asked for that I can highlight in the court. In the eviction, the landlord can never recover late fees from the court. State law says that in the eviction, the landlord can only seek actual unpaid rent and their costs of court to bring the case. It may be that under the lease, you owe things like late fees or utility fees or cleaning fees or pet fees or anything else that the lease says you owe is still owed potentially as a contract claim. For the eviction, I am only looking at base rent. So today I determined that monthly rent, everyone agrees, is $2,300. So the judgment amount would be for $2,300. I would only award the month of May. I'll leave it up to y'all about the June portion of things. And then for appeal, it would be that same thing, appeal bond of $2,300. Now, Mr. Funk, you and Ms. Chang, I want to say this to you as well. Sounds like parties are not too far apart in what's trying to be sought here. If in the next 5 days, y'all come to an agreement, and Mr. Funk, I'll be clear, Ms. Chang does not have to come to any agreement with you. The fact that you did not pay in full back in May means you have violated the lease and she can move forward with it. Just as you could sue people who have not paid on the invoices that are outstanding to you, right? That is her legal opportunity. Just because she can doesn't mean she has to. If in the next 5 days y'all come to some agreement and Ms. Chang tells me that she wants me to throw out the order of eviction, I can do that. But she has to tell me, and she can only tell me within 5 days. If y'all go beyond that, it becomes a final order. Now y'all can still resolve it with each other, and she can do something called a release of judgment, but that's sort of after the fact, right? Mr. Funk, you can absolutely reach out to the landlord today, and if y'all come to some agreement, great. You also absolutely have your right to appeal, as does she. To appeal the decision, you must do that within 5 days. The appeal bond that I mentioned, the $2,300, well, you kind of indicated that you may have the cash for that, so this might not apply to you. But I always highlight that if you can't afford it, people can apply for what's known as an affidavit of inability. We'll send you that information. We automatically send it to both sides. Take a look, see if it might be useful to you. All right. Again, though, late fees can't be part of the eviction. That may be a dispute between the contract breach ongoing. And then same thing, I'll just, for both parties, Mr. Funk, just as information, your landlord is required to provide you with the final itemization at move out. And that's required as part of the accounting of your security deposit. So even if you have not heard yet, there is something that will kick in. And so you might want to look under the property code or take a look at the tenants council rules about what happens with your security deposit and what duties does the landlord have to you on those. Okay, sir?
Can I ask a question?
Your Honor,
Absolutely, Mr. Funk, what questions?
Your
So
Honor,
if
that's
I-
I told
Ms.
him.
Chang, hold on, Mr. Funk's asking a question. Yes, Mr. Funk, what was your
Go ahead,
question?
Ms. Chang, please, go ahead.
No, Mr. Funk, I gave you permission first. What is your question?
Sorry, I was raised ladies first.
I appreciate that, but
So
I'm in charge.
because the fact that I have the 2,300,
She doesn't
And
have to accept it because you didn't pay her on time. I always give the example of you stood me up for a date. You may be a wonderful person to date someone else, but like I got dressed and was waiting around all night. You didn't come. She hasn't had money for an entire month. If she says, nope, he owes it and I want him to leave, she legally can do that. She doesn't have to, but
so
legally,
if she does that, she just keeps all of my security deposit as well?
no, Mr. Funk, please call attorney about what happens to your security deposit. The fact
Well, I
that she
don't have
evicts
money
you
for
does
an
not entitle
attorney.
her to your security deposit. These are very, very different things.
So can I ask one other question? In all
Yes.
the documentation that I provided, do you have that? Because in my
Mr.
documentation,
Funk, there is no dispute of fact. You did not pay rent in May.
I'm not
That is the
trying to
only
dis-
question of fact for the court to find
I'm
an
not
eviction.
trying to dispute, just like I said in my statement. I was
Right.
trying to ask a question. And I thought that it showed in my text messages when I clearly asked for, the ledger so I could see late fees and everything.
She doesn't
And
have
I
to provide that
understand-
to
I
you.
understand. Can I finish my question real quick?
Okay.
And I understand that that's not required, but her response to that was get a lawyer to explain your lease and I'll see you in court. So my question to you is, it doesn't seem like she's gonna be very open for negotiating, even though I have the money. So I know fair doesn't exist in the court.
Mr. Funk, if your question is, how do you convince her to work with you? I can't do that. She doesn't have to. You
Okay.
breached the lease when you didn't pay it. Please contact an attorney or contact Ms. Chang, but I can't provide you any additional assistance. Okay?
Okay.
All right. Very best of luck. Mr. Funk, thank you for coming. Thank you for having all that information. Ms. Chang, I leave that up to y'all. Judgment for plaintiff, it's 2,300 plus cost of court. That's it. And then either party can appeal based on monthly rate of 2,300.
So I have to pay $2,300 just to appeal?
Mr. Funk, that is the appeal bond. Yes, because otherwise it's considered just a delay without any penalty. Please contact an attorney about the appeal bond. If you can't afford the appeal bond, you may qualify to appeal with an affidavit of inability. But people have to put money down to keep a case going. All right, all parties are excused. Thank you very much.
In the end, the court ruled for the landlord because the unpaid May rent wasn't in dispute. However, the judge also clarified that late fees and security deposit disagreements are separate legal issues and don't determine whether an eviction should be granted. He even encouraged both sides to reach an agreement within the 5-day window before the judgment became final. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.